Your Honor, this is a case that started as a child support action and then was converted into a custody action. There's a 4-year-old child between the parties at this point. The child has lived the majority of his life up until these proceedings with the mother. Father had limited contact for quite some time, but upon seeking child support, he sought time with his child. Ms. Hewitt represented herself for quite some time in these proceedings, and importantly, there were orders that came down regarding visitation and what that looked like and what that would be. Importantly, the court considered and granted some unsupervised visitation right before Christmas, where the father would have, I believe it was on weekends, from 8 a.m. to 6 p.m. on Saturdays to come see the child at the mother's home. Subsequently, there was a motion filed on January the 21st of this year that was set for hearing on the 29th, a week and a day later, that effectively asked for the court to flip this custodial schedule at that point, citing some issues and some things that the father had concerns regarding. At that time, notice was mailed to my client, but she never physically received that notice. She had been here for every single other hearing that had occurred except for the one where she did not get the notice in time. And with not having the notice and without being here, the court entered the order where the father had the majority of the time with this child and put some onerous terms on the mother, including making her responsible for transportation and some other costs that father knew that she could not afford. Mother currently does not have reliable transportation, and the criminal contempt that we're seeing is related to that and some of the transportation issues that came from this order where mother was not noticed and did not know to participate. At this time, the child has not had much time at all with the mother since that order came down. I believe there were maybe 2 or 3 visits since January that the mother has had because of this transportation issue. The father lives over 2 hours away in Kentucky with this and has taken this child and has in no way facilitated any of that contact. Instead, when mother asks and tries to communicate that she has difficulty transporting and moving this child, he shows up with the police and files this criminal contempt. We will say that this child is at substantial risk of harm, that he has been completely severed from his connection with his mother, that he was raised primarily by his mother up until January of this year when this court changed course, and that he is not...
Buckle up, guys. Today we're going to break down a case that spiraled from routine child support into a full custody battle. This opening sets the stage as we learn the child lived mainly with the mother until the court granted the father unsupervised visits. But one missed notice flipped everything. Suddenly, custody shifted, obligations piled up, and the mother was left struggling to keep up. This moment marks the beginning of a tense legal unraveling.
Not having the stability in the placement that he needs, that he's been removed from the home that he's known, the family that he's known, including his sisters and other siblings, that he has not been getting the therapy and the other resources that he was getting through the Dixon County school system in Kentucky, and that we are seriously concerned about where this is going and what is happening to this child with this change in custody. And again, we're just seeking to go back to the status quo and then reassess and see what we need to do moving forward, because we're not denying and saying that he can never have time with this child. We're just saying that this change is too much and too fast for this child that does have some developmental delays and does have some other issues. Ultimately, father set mother up for failure unilaterally at that hearing on January the 29th, and now, in addition to the motion for criminal contempt, they filed a motion for a parenting plan, where if you read their proposed parenting plan, it gives father 365 days with this child and mother 0. They are trying to control the situation and take this child away from the mother. And am not disputing that it was mailed or not mailed. We don't know, but what we can say is that mother never received this notice. She was not participating in that hearing, and ultimately we're seeking this child to be able to return to mother because there have been no substantive issues that have brought about this change in custody.
Deal first with the motion to reconsider this case for some of the history. This case initiated, as was pointed out, by a petition to establish paternity and for support. That complaint to establish was filed in September of 2024. An order went down in November of 2024 to establish paternity and to establish a child support obligation. And from that point, and in fact, I think I'm the one who signed the order of confirmation of that. Then following that, there was a petition to establish visitation that Mr. Fenton had filed, and that came before the court, and we ended up having a hearing, and there was order of visitation that went down. During the hearings, both in that and the parenting time of Christmas of 2024, Ms. Hewitt appeared pro se and testified about the extensive medical conditions that this child suffered from and how this child had heart issues and other major health issues that she was addressing, and that was her opposition to having overnight visitation with Mr. Fenton.
All right, guys. Here the tension rises as the mother's lack of transportation becomes a major obstacle, turning simple exchanges into moments of conflict. The father shows up with police, the child sees his mother only a handful of times, and emotional separation starts to take hold. Concerns escalate over the child's stability, routine, and loss of familiar support. The mother's team argues this abrupt shift risks serious emotional and developmental harm.
That I found that at the December 18th, 2024 hearing, the mother testified that she had objected to unsupervised visitation due to the minor child's various medical conditions and treatments. However, the proof overwhelmingly at that hearing in January established the fact that the mother was either untruthful or ill-informed, both of which are unacceptable for a primary parent. The mother also testified that she had been managing and fulfilling the minor child's medical care and developmental needs. However, the proof was overwhelming that the mother had failed to meet the child's needs. The court finds that the mother delayed the child's access to services from Tennessee Early Intervention Services for about a year. Furthermore, the child missed 2 consecutive months of developmental therapy by April 12, 2022, due to the mother's failure to cooperate with the therapist. The mother also delayed the child's access to physical therapy and failed to have the child evaluated by a speech therapist and ophthalmologist as prescribed in the child's PCP, which is primary care provider Carol Moore. I found that the child requires evaluations and follow-ups for autism, speech, ophthalmology, as well as a well baby checkup and a 2-year follow-up with a cardiologist. I found that the mother had neglected the medical and developmental needs of the minor child, and that the overwhelming evidence demonstrated that the mother was not capable of providing the care the child required. The father had actively sought to arrange for the child to receive necessary medical evaluations and treatments, and he has demonstrated both the willingness and ability to meet the child's needs. He testified that the minor child did not experience any issues in his care during his residential time. And I went on to find that I considered the factors in Tennessee Code Annotated 366106, and I found it was in the best interest of the minor child to designate the father, Matthew Christopher Fenton, as the temporary residential primary parent. And I went forward then to set a residential schedule for the mother. That is the order that I entered. That is the order that, in my opinion, should be upheld, and I am of the, at least, I'm not going to grant the motion to reconsider because, in my opinion, proper notice was given, and there was a factual basis for the rulings that I made at that time. I will then overrule the motion to reconsider and move on to the motions for contempt.
I'd actually take him with me.
Okay. So the first 90 days, you were to have supervised visitation at Miss Hewitt's home. Is that what you stated?
Yes.
And and what time from what time was that?
From 12 to 9.
12 to 9. So you had a hearing August 30 of 2024. So when was your first supposed visitation?
The following day, it would have been August 31st.
August 31st of 2024, is that
Yes,
correct?
yes, ma'am, correct.
Okay. And let me go back. During the hearing of August 30, 2024, Ms. Hewitt, was she present at that hearing?
Yes,
All the way to when the judge made his ruling on your specific visitation?
yes, that's correct.
Okay.
Now the case takes a sharp turn as the judge lays out detailed findings, painting the mother as medically neglectful. Missed therapies, delayed evaluations, and unaddressed developmental needs build a narrative of consistent failure. The father is portrayed as proactive and prepared, meeting every requirement and arranging necessary care. This portion is pivotal, as it establishes the factual backbone behind the dramatic custody shift now at the center of the dispute.
All right. And then so the first day that you visited, August 31, 2024, were you able to see your son that day?
Yes, for a short period of time, about an hour and 20 minutes. And Miss Hewitt had told me to leave, that I would not be coming around there every other weekend. And so I left.
Okay. And so your time was cut short. So if you had from 12 to 9 p.m., so that would be 8 hours, correct?
Yeah, well, no, 9.
9 hours?
Oh.
I'm not good with math. I think it's 8 hours.
Oh.
And so then so did you say that you only visited about an hour and a half that day?
Yes, it was
Okay.
about an hour and 20 minutes or an hour and a half.
Okay.
And I was asked to leave.
Did you perceive any reason why you shouldn't be allowed to complete your 8 hours of visitation?
No, she just got very rude and told me exactly that I needed to leave, that I would not be coming around there every other weekend,
Okay. And so that happened August 31st.
or every weekend, I'm sorry.
Okay. All right. So then let me take you to September the 28th, 2024. Tell me what happened on that day.
See, August
What was
31st.
the date again? I'm sorry.
Was that,
September 28th, 2024. Did you send her, did you let her know that you were going to arrive?
yeah, I let
To
her
her
know I was
home?
going to arrive, and she had messaged me and said that it was her stepmother Connie's birthday, and that she was be going to her father's for that, and wanted me to reschedule my visitation for the following weekend. And I messaged her back and I let her know that, I'd been waiting all week to see Ashton, and I did not want to miss my visitation. And she brought up child support, and had I sent it yet? And I just let her know that I was be on the way. And she messaged me back and said that she would call her father if I sent the child support and see if he could come later in the day to get them and postpone the party till later that evening. And I told her that would be okay. And then she messaged me again about child support, and I didn't respond. I just let her know that I was heading that direction. And right before I got there, she had sent me a message that she had left, or maybe when I got there, I can't really, it's been so long ago. I might have pulled up. I think it was 12:04. I pulled up and I messaged and said, "I'm here. Are you at your house?" And she messaged back and said that she had already went to her father's house, and they would not be back until later that day. I think it was 8 o'clock. And that
Here's where the judge doubles down. After reviewing evidence and procedures, he refuses to reconsider his earlier ruling, declaring that proper notice was provided and the facts clearly supported transferring primary custody to the father. This moment reinforces the court's confidence in the original decision and closes the door on the mother's attempt to reverse the outcome. The courtroom tone shifts. Now it's all about accountability and consequences.
I couldn't have visitation.
And so on that day, September the 28th, 2024, was that a Saturday?
I believe so.
So that was an appointed day for you to have your visitation, is that right?
Yes, ma'am.
And you did not have the visitation? Is
That's
that
correct.
Participants in that text messaging?
Me and Ms. Hewitt.
Okay. And You did say October 26th is the date on that text message?
Yes, it says Saturday, October 26th at 12:14.
Okay. Is that another day where, is it your appointed day to
Yes, that's
exercise
correct.
your residential time? Okay. And so read that text message for us.
She said, I text her and I said, I'm at your house for visitation with Ashton. Are you at home? She said, no, we're at Daddy's for his birthday this time. And then I replied, today is visitation, so are you coming back? She replied, well, you change up Saturday and Sunday whenever you want. And I text you about his birthday and got no response. That was completely false. She had never texted
Just
me.
go ahead and read.
And then I've replied, you must have texted the wrong number. I've alternated every other week, like the judge ordered. And then it said, I replied to this. I said, we went to court on 8/30/2024. Visitation started the next day, which was Saturday. And she replied, Connie's cooking and got him a big cake.
Is that the end of it?
Well, no, it keeps going. I just got to flip the page. It didn't show it all. But she had replied, Connie's cooking and got him a big cake for Paw and giving gifts.
In this segment, the focus moves to the father's testimony about early visitation breakdowns. Each scheduled visit becomes a point of conflict, cut short, redirected, or outright denied. The father describes last-minute excuses, birthday parties taking priority, and a pattern of evasive communication. These accounts lay the groundwork for contempt claims, showing missed opportunities and frustration building on both sides. The tension grows as texts reveal a widening gap between court orders and real-world actions.
And she said, I'm sorry, but I text you and you weren't at Daddy's for his birthday. That text you that we were at Daddy's for birthday. And then I said, I replied, that's no excuse, it's contempt of court. She replied, no, it's not. We had a prior engagement and I text you. And then she replied again, we have had lives over 3 years without you and still do. Stuff comes up, that's life. And then I replied, I'll file contempt of court on Monday and see what the judge thinks about it. And she said, okay, and then she sent me a thumbs up.
Okay. So Judge, I will play
Is it an audio recording?
a video recording.
Video.
So do you recognize that?
Yes, ma'am.
And where is that taken?
That is at Amy's house, right?
And who was taking that?
I was, because I pulled up and I got
I'm just asking who took that?
I took the video.
Okay, don't explain. And then what time of the day did you take that? Was it at the beginning of your visitation?
Yeah.
At the beginning of your
Right at 12
visitation.
o'clock, as soon as I pulled up, yes.
Okay, right at 12 o'clock.
Your fiance that runs her mouth about my goddamn daughter and shit. No. Give me my baby now.
I'm here for my visitation, Amy.
Yeah. Not here. Grab your brother. Grab your brother.
The confrontation reaches its peak as messages escalate and the father records an in-person encounter at the doorstep. The video captures raised voices, accusation, and complete breakdown in cooperation. This moment illustrates how strained the relationship has become, with court orders overshadowed by personal conflict. As the judge seeks clarity, the scene shows exactly how quickly these situations can unravel when trust is gone.
He's all right.
No, he's not. Give me my son.
All right. So I need to just leave then? Is that what you're
If
telling
you
me?
don't want it to have visitation like you're
I'm
supposed
visitation in your house, right in front of it.
to, that's not my fucking house.
This is your house right here.
That's not your truck.
My truck is
The
in front of your
parking lot
house.
Is not my house.
All right, we'll take that.
Explain what was happening in that in that situation there?
I pulled up, I knocked on the door for visitation at 12 o'clock. Miss Hewitt was in the back room. When you walk in her house, you go to the living room, and then there's a hallway, and she was in the very back room in her bedroom. I'm assuming because she had walked out that way. But her daughter had answered the door.
And that's it for today's video. Thanks for watching. Make sure to like the video, subscribe to the channel, and we'll see you in the next video.